Radio Free Mormon here, broadcasting behind enemy lines. Tonight's episode 464. This lawsuit is weak. Good evening, everybody. Welcome to Radio Free Mormon. As you all know, the LDS Church filed a lawsuit against John Dehlin and Mormon Stories, alleging that they've been violating the church's trademark for 20 years while the church did nothing about it. That's going to be a problem for the church. The other thing that's going to be a big problem for the church is distancing themselves from the word Mormon since 2018 and President Nelson's ascendancy to being the prophet of God on the earth. This is going to be a real problem for them. There's been a lot of talk about this lawsuit because John Dehlin just filed his response this past Monday. We're going to talk about this tonight with two lawyers. I'm going to be one of the lawyers, me, RFM. The other lawyer is going to be my esteemed co-counsel, Kolby Reddish. And we're going to talk about this lawsuit, hopefully break it down, try and make some sense of it to the average person. It's going to be a great discussion. I hope that you will enjoy it. It is already been broadcast over at Kolby's new channel called Let's Disagree. That happened on Friday. This is premiering on Saturday night. I wanted to give him at least 24 hours a head start on this, but I also wanted to announce here that it's available there. We've got a great channel there. You should go and check it out. Now we're going to talk about what it is that happened at this interview. This discussion is about 2 hours. It covers the ground well. It covers some new ground in addition and some new ideas that came to me. And also, I got some new ideas from Kolby about this lawsuit. I hope you will enjoy it. Let's play the tape, sit back, grab the popcorn, and enjoy, shall we?
Hello there, my favorite randos on the internet. Thank you for joining me on today's episode of Let's Disagree and Other Interesting Conversations. And I am so happy to have joining me in the studio, Radio Free Mormon. How are you, my friend?
I am great. Thank you so much. Technically, I am in a studio. I don't know if it's the studio. I say that all the time. I think you're supposed to say that when you're actually in the same room together.
That's right. Well, my studio is broad. People don't know that panel wood is just on the other side of my bedroom. So
your studio is broad and mirrored.
That's right. Well, thank you, RFM, for joining me on today's episode. We are going to give folks a brief breakdown of the three largest questions that are going to be answered by the LDS Church and Mormon Stories, Open Stories Foundation, John Dehlin lawsuit. I am going to focus really on the three largest questions that will get resolved by this lawsuit because you already have done such an excellent job on your coverage of this on the Mormon newscast. Oh,
Except
here, I've got something for you.
I got the church's law firm wrong repeatedly because it's not Curtin McConkie who's representing them. Apparently, they got some outside legal help with expertise in this area. Everything I said about Curtin McConkie that was derogatory, I stand by and transfer all those comments I made about Curtin McConkie to these new attorneys because I think they deserve it.
Yeah. Aside from that, so for folks who don't know RFM, RFM and I have been longtime collaborators now for the last several, 4 years, where you were nice enough to guest host me on your podcast, Radio Free Mormon. And that coverage that you're talking about is on the Mormon newscast. So for folks that want to check that out, I will put a link in the show notes where RFM spends, it's a breezy 3.5 hours, but spends 3.5 hours reading through the entirety of the Mormon Stories answer and counterclaims. So we will get the slides up here.
And that was just my guided tour through it. We did not read them all. We'd still be doing the newscast, and right now it's Thursday night when we're recording this.
That's right. If it's like that phrase in John, right? If all the things that Jesus did were written, if all the paragraphs in this complaint were rehashed in a podcast, it would still be going to this day.
As I read through those 125 pages, the question that kept coming to me was, where did all the words come from?
Yeah, you can't just generate 125 pages. Oh, that's classic. Well, RFM, thank you again for joining me on today's episode. Here's our thumbnail. You said that you are not a fan of this particular AI claimation.
That's okay. That's why I try to avoid that particular angle. It makes my hairline look more receded and my eyes look more bulbous.
Well, I look like I belong in a cave playing riddles with Bilbo Baggins a little bit, I think. So
That's very nice. Riddles in the dark.
that's right.
I look like Taurus bulbous, as a matter of fact.
Oh, RFM, I always have such a good time recording with you.
I'm really glad of that too. This will probably end up being edited out later, folks. You'll never see it. It's okay.
You're assuming I do any editing. So on the left-hand side of the screen, I've got a snippet from the front page of the church's and Intellectual Reserve's complaint against Mormon Stories and the Open Stories Foundation. On the right-hand side of the screen, we have the answer and the counterclaim. Now, one of the reasons that I've snipped it the way that I have is because we are going to really talk about the questions that will get settled by this lawsuit. So I am going to try and do my best to stay as objective as I can on just talking about what will be decided by the court in adjudicating this case. And the reason that I want to do that is because when the church filed its complaint, there were so many apologists that were and members all over the internet that were rushing to tell everybody how right and justified and righteous the church's case was. And I don't want to be as reactionary on the other side of things. So really, the reason I have these two documents side by side, or the first page of these documents side by side, is to basically say it's important that people understand that pleadings, which both a complaint and the answer are pleadings, which originate a case, and will kind of orient people on the basics of just a high level of civil procedure here in just a second. They are not evidence. They are what a party is hoping to prove at the ultimate trial. And so we are going to be looking at paragraphs from those complaints, from the complaint and the answer. We'll be looking at some documentation that's included in the complaint and the answer. But it's important to say at this stage that really there are so many unknowns in this case that I don't want to jump to judgment on too much. Do you have anything you want to say as we get started?
No, I'm just glad that I held my boos and hisses when you showed the different filings.
Yes, I appreciate that. You're saving me editing time.
That's
So
what I
here's
do.
just a brief overview of the civil litigation process, because one of the things that you and I share for folks that have never run into Radio Free Mormon before and are encountering him for the first time here on my channel is RFM and I are both lawyers. And so we share that kind of common interest. That's how we kind of analyze things. And so from a high level overview, maybe we can just alternate the 1, 2, 3, 4 back and forth RFM as we go over kind of these bullet points of how a case progresses through the system. But cases start in civil litigation, at least, they start with pleadings. So it starts with either a petition or a complaint, some other type of filing. If there's some nuance of, a particular statutory remedy, those pleadings are either the complaint and the answer, and they basically, like I said, they initiate the lawsuit, and they really are the party giving notice to the other party and to the judge, and basically to the world, if the pleadings aren't sealed, of what they hope to prove at this trial. One of the things that was interesting to me is there were so many apologists that made a big deal about the church demanding a jury trial in their complaint, and that is just, as you know, just boilerplate pleading, because if you don't assert that right, then you may have waived that right. And so it was funny to me to see people who don't have any knowledge or insight into the system making a big deal of that, when really that's just standard legal boilerplate. So after this pleading stage, we would proceed to the discovery stage. If you wouldn't mind just talking about that high level RFM.
Right. So this is something that came up on Monday because it was a surprise to some people when they asked, what does the judge think when he reads this? I don't know. He probably hasn't read it yet. When does the judge read this? No, he hasn't read it, and he's not going to read it until he has to make a decision, right?
Right. Almost certainly hasn't read it.
Because he's got a ton of other things on his plate and other things that he has to read for decisions he has to make. Up to this point, he doesn't have to make a decision. So why borrow trouble? Okay. So anyway, I mentioned that to them, and that this kicks off the discovery process. Technically, there's one more filing that has to happen, I believe, and that would be from the plaintiffs, the church, to respond to the counterclaims that were made by John Dehlin. So that'll be the last required filing that they'll have to do within whatever it is, 60 days or so.
I think isn't it 21? It's either 21 or 28.
I can't remember. I don't know if it's the same length as the response to the initial complaint. is required, but whatever it is, they'll have a time limit and they'll have to file that response, and we'll see what it is that they say.
It's
The
also
response
very,
to those things.
I would say, since I do practice civil law, and I know your background is more in criminal law, it's
Mhm.
pretty common in civil litigation to have agreements on these early deadlines up to 60 days. That's pretty common. No, I think the normal timeline that's in the rule is actually a lot shorter than that, but it's pretty common to just agree, hey, we'll give you 60 days if you,
That makes sense, 'cause up here it's
waive
really 20
service.
days. It's 20
Yeah.
days, but that's
Mm,
kinda short to d especially in a case like this. Can you imagine having 20 days in which to file that 125-page thing and
mhm,
come up with it and create it and research it and all that other stuff?
right.
Yeah, I can see why. Okay, that makes sense. But anyway, that's really kicks off the discovery phase, which is basically 3 things. This is now where the parties, uh, gather evidence that
Mhm,
they hope will help them in their case, and they are basically you can ask questions of the other parties. You ask them in writing. They're required to give answers to those. Those are called written interrogatories,
mhm.
because we don't call anything just questions in the law. No way. It's
It's why we can charge
interrogatories.
so much for our time.
And we don't just send the interrogatories, damn it, we propound them. These are propounded interrogatories. Doesn't that sound a lot more impressive than written questions? So you get to ask questions up to a certain number. You also get to request documents and other items from the other party. And those are requests for production. That actually sounds like what it is. It's a request for the production of documents. It can be other things, requests to
Mhm.
inspect, whatever. And the third thing in the discovery process is going to be interviewing witnesses, which is done under oath and recorded, and those are called depositions. So all of that is going to happen after these initial pleadings are filed. I did make it clear to everybody else, though, that I'm sorry, this is the civil litigation process overview. Let me just go ahead and say it. So if I forget it,
Mhm.
I will have said it. Is that John's side filed a motion to dismiss,
Mhm.
which is different because that's going to require it's filed separately. It's going to require a response from the other side. This is not the pleadings process, okay? The normal pleadings with the plaint. Okay, this is motions practice. They're doing a
Right.
motion to dismiss. The other side's going to have to file a response to that motion to dismiss, and they can file a reply to that if they want. They've got to have it scheduled and have it in front of a judge and argued and heard and ruled on by the judge. And that's probably going to happen before any of this other discovery stuff commences.
Right. And that actually leads right into the third, which is dispositive motions. Because one of the things about the civil litigation process
Right.
is that these stages, they aren't as sequential as people might necessarily think, right? You actually can propound discovery at the same time you file initial complaint if you want to. For example, I've done that before when I really like if the case was a follow on from another case and we already kind of know what the issues are, that can be a common practice. And yes, the motion to dismiss, which John has filed, is based on the theory of it's based on the theory of saying to a layperson, I'm going to admit everything that you've said is true for purposes of this motion. And then ask the judge to make the decision that you still aren't entitled to any legal relief. It's known as the theory is known as either a demur or a failure to state a claim upon which relief can be granted. And so that is a form of dispositive motion that can actually be made in place of an initial pleading if you're a defendant or alongside an initial pleading, which is what John's lawyers have decided to do in this case. There then is basically a second phase, I would say, in most civil litigation of dispositive motions, a motion known as a motion for summary judgment, which can actually incorporate some evidence. So the important difference, I guess, between a motion to dismiss and a motion for summary judgment is that a motion to dismiss really cannot contest any of the potential evidence that the other side is alleging they will be bringing to trial. You are admitting that those things are true for the purposes of the motion. A motion for summary judgment can look at non-contested facts that have been discovered through this discovery process, including citations to deposition transcripts, deposition testimony. And so it is basically a second phase of saying, hey, judge, even in the best case scenario for this other side, we still win. So that's the way to think of dispositive motions. And then, of course, there's other motion practice that can go back and forth. I don't know if there will be expert witnesses in this case. I imagine there will be some, but it's not like when I did civil litigation, in court. I did like valuation cases similar to our friend Randy Bell, but I was representing the state, not private clients, and for different purposes, for property tax purposes. And we would always have multiple expert witnesses on those cases. So expert witnesses are another thing that will happen during this discovery and motion practice phase of a litigation, where you're trying to keep certain things the other side wants their expert to say out, or you're trying to support things that you want your expert to be able to say. Anything you want to add to motion practice or dispositive motions?
Yes, that there can be overlap, but it is helpful to keep it sequential in the mind, at least for me, because one, you got your pleadings, two's the discovery, and that's when you find out who their witnesses are going to be, what they're going to say. You get to find out what their evidence is. They get to find out what your evidence is. So once that's completed, you are in a place to know what the case is, what the facts are, what the law might say when applied to those facts. And now you're in a position to draft and file some dispositive motions, or motions that aren't dispositive, okay, about the case, to have things taken care of that need to be taken care of. And then once all that's done, now you're ready for the trial. And everybody knows that because Perry Mason and all that stuff. So you go to trial, there's a jury, and doesn't have to be, but there could be a jury, could be a judge, but there's going to be a trial with a lot of evidence. And at the end of it, the jury is going to make a decision. And that decision is either that the church is right and John Dehlin did abuse their trademark or use it in such a way as to cause confusion among consumers about whether he was really the church. Yeah, that's going to be a tough one. Or whether the church is wrong and he didn't do any of that. That's going to be the ruling from the court.
And one thing I guess it's important for folks to understand, even if there is a jury involved in a case, the judge still makes some significant decisions. The basic like swimming lanes that we're talking about here is juries are the finders of facts and judges make any of the legal decisions. So when it's actually about the application of the law, even the application of the law to facts that the jury has found, those are decisions typically reserved for the judge. Then after trial, and I am almost certain we will see this in this case, unless it settles before. I guess it's. I was going to say the fifth phase is appeal, but I was going to pause and say, because you asked a trial kind of quizzically. Most civil litigation, and when I say most, I mean like 90+% civil litigation settles well before we ever get to trial, usually sometime in the discovery stage, or it might be resolved partially on a dispositive motion or a non-dispositive motion. Like if you win a motion that keeps another side's expert witness out, that's key to them presenting their case, for example, that is in effect a dispositive motion because they really can't prevail at trial if they don't have, their key witness involved. But what I was going to say is, just based on the significance of this case for the church, I would not be surprised at all if this case, if it actually does proceed to trial, which I do expect it will. I don't think the church would have decided to pull the trigger on this, to do the press release they did along with kind of the press tour that we saw all over the pro-Mormon podcasting circuit, if they weren't determined to at least take this to the trial stage. But I could be completely wrong about that based on the strength of John's answer and some of the counterclaims after reviewing those. And we'll get into that in just a second. But
certainly,
I guess...
certainly if John's motion to dismiss is successful, it will not proceed to trial.
Right. Yeah, then it's just over. And there are significant questions on that. We'll kind of wrap up by talking about that motion to dismiss and the theories pleaded in that motion to dismiss. But after trial, you get the chance to appeal. I actually have spent my career really specializing in appellate work. And so one of the things I like to tell people about appeal is not just a second trial. An appeal is actually a formalized analysis of legal error. You are saying that the jury or the judge committed a specific legal error that entitles you to some particular relief. It might be a new trial. It might be that the case should be dismissed. So the likelihood of appeal, if this case actually does proceed to trial, I personally think is very high, because I'm sure that the church wants to continue to push its interest in furthering religious freedom and First Amendment grounds. And even though...
Is that answer that you're giving already concluding the church loses the trial?
I'm saying if it would, yes.
Yeah.
And I think either way, both parties, if we get all the way to the cost and expense of a trial, I think both parties have significant issues that they might take up on appeal because they are First Amendment issues both ways.
Well, there are, but John Dehlin doesn't have as many dollars as the church has. He may
It's
have as
true.
many issues, just not as many dollars.
It's true. And that obviously is a big practical reason that we might not see an appeal. And then ultimately,
by the way, I did say something, I think it was at the end of Monday's show, that
Mhm.
I gave the wrong impression, I think, because I was talking about, no, that's not always the rich person wins in the law, okay? That much is true. It is not always the rich person that wins, but if the church gets to trial and loses, then they can appeal the hell out of this
Mhm.
as far up as they possibly can, and that's a
Mhm.
lot. That's a number of steps, and that would require a great deal more expenditure of funds by John Dehlin for attorney's fees on appeal. And yeah, that could be crushing, and people do get crushed by that and just stop because they can't afford it anymore.
Absolutely. It's actually one of my, I mean, the system we have is the system we have, and it's much better than other countries have in certain respects. But one of my least favorite things as an attorney is having a client that has a super justified case on the ethics and morals, and that they just don't have the money to make the case economical. It's one of the hardest conversations you have to have with a client is, do you want to spend, do you want to spend 60 grand to chase after 40 grand is often the conversation that I would have to have with people.
Right.
And then after an appeal, there is some type of resolution. And again, these stages are not necessarily sequential, though they kind of are. So we could see resolution, through a judgment at trial, before trial, like you said, if the judge grants John and Mormon Stories motion to dismiss, that would resolve the case right there.
And
There
that,
is
by the way,
always
just so everybody knows, I'm sorry, Colby,
Mhm.
that decision can be appealed and would be appealed
Correct.
by the church, I would presume. If the judge grants John's motion to dismiss, the church will appeal that.
Correct. Yeah. And the likelihood of settlement always is going to be kind of the backdrop of that. That's the thing about civil litigation is this is a little bit like a poker game. Like the discovery phase is a little bit like the bets going back and forth because you get to see a little bit of the other side's cards and their chips and what they're holding. And that could spur a settlement. That's where most cases that I've worked on settle is in the middle of discovery.
And the church is doing all this over the word Mormon. Everything else, I'm convinced, is window dressing. They're doing it all over a word that they have distanced themselves from and affirmatively eschewed since 2018.
Mhm.
This is what they're doing this for. And it's a little bit like Captain Queeg is in charge of the Mormon Church now. I think that's the reference. Humphrey Bogart, Cane Mutiny. Yeah, he loses his marbles and starts acting erratically, and the crew has to decide when they're going to have to be forced to mutiny to
Mm.
take over the ship.
Yeah, the church makes such odd decisions. They're odd, but also weirdly predictable. So I'm not at all surprised that they decide to bring this lawsuit, especially with the change in the leadership of the church when President Nelson passed and President Oaks is a lawyer. For folks that don't know, he previously sat on the Utah Supreme Court. So I think
Yeah,
he
there are
has
bad lawyers too, in case you didn't know.
there are quite a few of them, and a lot of them in Utah, is what I would say. But yeah, here are the three questions, and I think you kind of just hinted at the third one, which is, did the 2018 rebrand effort weaken any of the claimed intellectual property rights that the church has made the focus of this litigation? But here are kind of the three important legal and factual questions that will get resolved by this case. The first is, did Mormon Stories branding create legally actionable confusion? And even though we're trying to do a layperson breakdown, I used a little bit of legalese there with legally actionable confusion, but I actually did it for a reason, which is one of the things that I saw when the church filed its complaint back in April is I saw a lot of apologists making a big deal about confusion and
Mhm.
acting like there was so much confusion. No, acting like a single instance of someone getting confused or clicking on Mormon Stories or leaving a comment about Mormon Stories is actually legally actionable. And I'll give a good overview of this when we turn to that section, because that just simply isn't that isn't the case.
Well,
And
under trademark law, I once again, Monday night, I talked about this inexact interface between
mhm,
religion and this trademark law, because we all understand that if you got Nike, okay, you got the trademark to the swoop, and
mhm,
some other cat out there starts making shoes with swoops on them, and people start thinking these are Nikes, and they start buying them, and you're losing money. They're making money because they're ripping off your trademark. Everybody understands that lawsuit. The
mhm,
thing here is, John Dehlin doesn't sell shoes, and he doesn't sell Bibles, and he doesn't sell crosses or whatever they're selling at Deseret Book. Now, he doesn't do any of that. What he does is produces podcasts. And apparently, he's actually been producing podcasts since before the church was producing podcasts.
mhm,
So, this is his good. This is his service that he produces. And the question, I think, isn't just whether somebody walks by and looks at his swoop shoes, his fake swoop shoes, but whether they buy them and run in them. They have to buy them. They
mhm.
have to buy them, I think. And so then the question is, what is the analog to buying swoop shoes that are not Nike shoes with listening to a podcast on Mormon stories? At what point have you bought the shoe such that the church is losing money? Or is it
Mhm.
influence, or what is it exactly? It's not easy to get my head around.
Well, to prove damages, they would have to point to money, I would think, or some reputational harm, but I don't know how you measure like damage to a church. I
Mhm.
think you're right. It's one of the things that's so confusing, and one of the instances where, and one of the many instances where the church both wants to eat its cake and also have its cake, where it wants to use all of, I'm sorry, go ahead.
No, 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 you continue. You continue, please. I'll say something about the eating of the cake in a second.
It's where it wants all of the rights, privileges, and immunities that apply to being a church and all of the protections of the First Amendment that come along with that. But then when it suits them, they also want all the rights, protections, and privileges of being a for-profit corporation. Like you said, there is this indirect interface that is very confusing to me about the way that they have pleaded this case.
Mhm. I was watching the live chat from the show, the other night. It might have even been last night, and it was, somebody had said something about having your cake and eating it too, and there was a lot of confusion expressed about what that means, and I had the same confusion for a long time, and I
Mhm,
think I found out what it is. Okay, what this means is have your cake. That means to keep it
mhm.
uneaten, okay? To have your cake and eat it too, because people are saying, "Well, can't you do both at the same time?" Not if you understand that having your cake means holding your cake and saving it to eat in the future.
Right. That's why I
Okay.
phrased it the way I did, is because I used to have this confusion too.
Really?
And so when I looked up like the etymology of that idiom, if you go all the way back, it used to be phrased, eat your cake and also continue to have your cake, or something to that effect. And so I phrased it that way because I think it makes more sense. When
It
people say
doesn't quite
have
have
your
the
cake
same
and
ring to it though, does it?
it doesn't, but
Mm.
so many of those idioms, it's funny if you actually trace them all the way back, the way they're commonly used in our vernacular today is often the exact opposite of the original message. For example, jack of all trades, master of none. That's one that if you do some research on
Mm,
the original takeaway is the exact opposite of the way that it's used today.
interesting. We'll have to do a
So
show
back,
about that someday.
yeah, we will.
But like I'm
So
saying,
our
within this podcast, you've got a store in a mall and it's got the shoes. When you wander into the store and you're looking around at the shoes, and then you say, "Oh, wait a second, this is not the Nike. I want Nike shoes. I'm gonna go across down the hall in the mall and get the Nike store." If you do that, has there been anything that's actionable?
right. Uh, there is some allowance in trademark law for some initial type of confusion. In other words, trademark law does not prohibit every instance of consumer confusion.
Mhm,
What it's really aimed at is intentional deception. Now, not always. It does also pick up unintentional deception if it is leading to actual damage that can be
mhm.
measured in some way. But no, I don't think it should cover those instances. And then it gets so much weirder when we talk about, like you said, this indirect interface of a church using these what we would normally think of as commercial theories, like theories that exist to protect commercial interests. It's just such an odd thing, because any podcast that the church would be producing, like the one that they point to in the complaint, the Book of Mormon Stories podcast, which they started producing, I think in 2000, and it's either 2010 or 2011. I can't remember off the top of my head,
Either way,
but I
it's
know
after
it's
Mormon Story started.
right. Mormon Story starts in 2005, so it's either way, it's after. I don't think those would be commercial products anyways. So that's one of the odd kind of confusions in my mind of how this all will resolve, is whether the church can really even show any damages, which would be a requirement to recover anything from John. Now, not necessarily, the church would not necessarily need to prove damages to get some form of injunctive relief, which is where a judge basically tells Mormon Stories, you can't use the word Mormon, or you can't infringe on the church's intellectual property. But to recover any actual damages, you would need to prove up those damages. In fact, one of the most common discovery requests that I would make when I did civil litigation in court is itemize your damages, is to just send over that as kind of a standard. You can do it a few different ways. You can do it as an interrogatory, you can do it as a request for production, but you basically just ask the other side to articulate exactly what their damages are. And then if they don't do that, you've got a lot of ammunition when you actually get around to trial time, or if they do it in an incomplete way.
I know we're doing this overview, but I want to ask you this question too.
Sure.
We have all seen in recent cases, civil cases against the church that have been dismissed about that involve religion.
Mhm.
And sometimes, the plaintiffs are saying this doesn't involve religion, it involves, tithing and what's been taught about it. And the result has always been, no, this is religious stuff and we're not going to get involved because of First Amendment.
Yeah, that's known as the church autonomy doctrine, for what it's worth.
Yeah. To what extent, I didn't see anything expressly about it in the pleadings, but to what extent do you think this whole freedom of religion and this whole idea that churches do not, that courts do not want to get involved in resolving religious disputes will play in this case?
So I think the church autonomy doctrine is a much stronger defensive position than an offensive position. And I think for the church to basically bring a lawsuit and then assert church autonomy doctrine in any extent in this case, that's why I was not surprised to not see it in the pleadings, would be really odd. It's basically the same situation you can get into where obviously as attorneys, right, we understand attorney-client confidentiality and attorney-client privilege. We can't share information about our clients outside of that attorney-client relationship. Well, there's an exception. If a client sues an attorney, then basically they've opened the door to, well, I have to address what you've said. I kind of look at it in an analogous way, in that the church isn't, in all those other cases that you're asking me about, the Huntsman tithing lawsuit, the Gaddy tithing lawsuit, church autonomy doctrine featured into it, but the church was a defendant, an unwilling defendant. And I just don't see that doctrine becoming active here when the church is the one who decided to sue. That would be very odd, to basically say, you can't tell us what to do, which is basically what the church autonomy doctrine does, because the church is the one who brought this matter to court. I also just don't think that the church autonomy doctrine applies in any way to intellectual property claims. Like we talked about, intellectual property really exists to protect commerce and interests in commerce. And I struggle to see how the church would make a compelling argument to say these are matters of internal church governance, which is what the church autonomy doctrine exists to protect.
I am certain that I have inartfully phrased that question because I didn't mean to invoke the church autonomy doctrine. But thank you. That was a great lecture. It really was. No, I was riveted. If only all my law school professors had been that good. And I mean that, let me tell you. So here's the thing. Might the courts look at this? If the courts look at this the way that the John Dehlin is framing it, and I think it has some basis in reality, which is that the church is trying to silence or hamstring a podcast that says things about it that it doesn't want said, and identify the way it doesn't want to identify because it doesn't want people to know that this is about Mormonism, so they'll listen to it and find out about the bad things about the church. I think that's what's really going on. Not only freedom of speech, but also freedom of religion, in the sense that how are I'll ask you the question. Are John Dehlin's beliefs about religion and Mormonism protected by the First Amendment as much as the LDS Church's beliefs about the same things?
Oh, well, yes. The non-belief in religion is just as much protected by the First Amendment as belief in religion. The courts have been very clear about that for over a century. Um, I think where the First Amendment has the most interesting overlay here is the legitimate, and I didn't see this as cleanly in John's motion to dismiss, which actually surprised me. But I did also only skim the motion to dismiss. I saw it being premised off of fair use, which does kind of connect with the First Amendment in certain ways, but it is kind of a separate appendage, I would say,
Mhm.
of the First Amendment. I was surprised to not see just a plain First Amendment. This is First Amendment protected speech, the name of this podcast. And maybe that will come down the road in like a
Mhm.
motion for summary judgment, or you can make more than one motion to dismiss. So it's entirely possible they could make a separate motion to dismiss down the road. But that to me is where I would be taking this case is any because John isn't producing products that compete with the church in any way. He's doing commentary on the church. And
Yes.
if the First Amendment doesn't exist to protect commentary from being someone who's doing commentary from being
Mhm.
dragged into court on a case like this, I'm not exactly sure what it exists to protect.
I know. I think that's huge, the First Amendment freedom of speech claim. But also, even on top of that, you got the gravy of the freedom of religion.
hmm hmm So I think it is an overlay that I'm surprised hasn't become implicated yet. Um, at least as far as I've seen in the pleadings and the motion to dismiss.
Okay. I'm sorry. I'm
But it's a
doing a really
great
bad
question.
job of making this a super high overview.
No, that's okay. RFM, I knew that we would get in depth, and it's always worth it when we get a little bit in depth because
Okay.
you
Good.
ask such great questions, and I love our discussion.
I do
Um,
too.
I think our second question that we're going to explore that is how strong are the church's trademarks in Mormon and other related terms? Because trademarks apply for a specific purpose. There are broader purposes than other purposes, but that is one of the interesting parts of this case that we'll talk about here in a minute is the church's attempts to trademark the word Mormon broader than it actually has today and how that plays into the strength of the church's interest in these trademarks and intellectual property rights.
Yes, John's lawyers brought up something that the church didn't bring up.
Shocker. They've been hiding that for a long time, haven't they?
Yeah, we've been hiding that for a long time.
And then our third question you already hinted at is, in 2018, when President Nelson was still the prophet of the church, he called the use of the word Mormon or substituting the word Mormon for the church's full name, which is very funny to me because the church's full name in the revelation that he pointed to actually isn't the church's current name. We'll just set that aside for a second.
And
But
is that the use of the "the" or the capital T on the or something?
it's the hyphen and the lowercase d, but if you're deviating from it at all, it would seem that you're deviating from it. So it's very funny to me
God's
that
very
even
picky about these things, apparently.
apparently, I mean, it, yeah, you would think that shortening it to Church of Jesus Christ would be just as bad as shortening it to Mormon Church, but apparently that's fine. So
If I were God, I'd be happy if anybody remembered me at all. By whatever
yeah,
name.
well, he is a jealous God. So, yeah, our third question that we'll talk about is basically whether those rebrand efforts weakened any of the claimed intellectual property rights. So, starting with this first one, and I know I've already hinted at this, but it's important that folks understand that trademark law does not prohibit every instance of consumer confusion. That's why I've called this legally actionable confusion. Some confusion may be permissible. So, the question is whether the defendant's use of a trademark is likely to cause confusion among an appreciable number of ordinary consumers regarding the source, sponsorship, affiliation, or approval of those goods and services. And in the 10th Circuit, where this lawsuit is going to proceed in federal court, courts in that circuit look at a variety of different factors, not really as a checklist, but they kind of look at it under a totality of the circumstances. I know that's something that's replete all throughout the law, especially criminal law, is looking at totality of circumstances to make this decision. So really, I've only included this to say, really to counter the idea we heard from a lot of apologists when the church filed its initial complaint that some confusion proves the church's case. And it's like, It's actually a little bit more complicated than that, unsurprisingly. Do you have any thoughts on that?
Did you see how the response, the answer broke a lot of that down and showed that the vast majority of those cited cases of confusion came about from things that were gathered, comments that were gathered after it was public knowledge about the church was going after John Dehlin?
Absolutely. And you did a great job on Monday's newscast of asking the very good critical thinking question. If we're actually talking about legitimate consumer confusion, wouldn't we pull quotes from before the church had filed this lawsuit, after it had, or I'm sorry, from before it had done a press release, before it had riled people up about this issue? And the answer is yes. But it's important to note that even with this issue of confusion, modern courts have found that the Lanham Act, which is what pertains to theories under copyright and trademark law, the act does not prohibit momentary misunderstandings or confusion. I think a lot of those comments, when I was looking at the comments that the church included in its complaint, the theme I saw is members of the church who are so used to only hearing glowing things about the church because all of the information they get from the church comes from the church or other church members, that they were shocked and pearl clutching at the idea that anyone would be using that name or even speaking of the church negatively at all, regardless of the use of the word Mormon. I think it's important to recognize, like, what the church will ultimately have to show is that people were legitimately confused that the Mormon Stories podcast is an official product or an official affiliate or officially sponsored by the LDS Church. And honestly, I just don't understand how they will ever be able to prove that when you look at 5 minutes of an average Mormon Stories interview where, there are people telling their stories about why they ultimately decided to leave the church. Even if you just look at the last 10 thumbnails from Mormon Stories, I know the church has pointed to the use of certain copyrighted images in some of those thumbnails. John has basically fixed that issue after mediation. But even with that, I just don't see them being able to really convince a jury of 12, neutral people, or supposed to be neutral people, that anyone was actually confused that the Mormon Stories podcast was a product of the LDS Church.
Yeah. And confused to the point where they don't just, tune in for a second and clutch their pearls, but they hang around and they involve themselves and they actually believe this is coming from the church. How long do you have to listen to a Mormon Stories podcast before you know this is not from the church?
Mm-hmm.
And apparently, if you look at it in the about section, the description of the podcast, it says it's not affiliated with the church.
Right.
So I really don't see where the church has a leg to stand on. I did say last Monday that this is the kind of lawsuit that gets filed by people who have more money than common sense. I predict this will be dismissed at the motion to dismiss by John Dehlin.
That would be very interesting. And then it would proceed up through appeal, presumably. Yeah. I mean, it will be interesting to see what happens with that motion to dismiss. I hope that it's adjudicated quickly by the court, but judges, I've had judges before where I was absolutely convinced I was going to win on a motion to dismiss stage, and they just took the motion to dismiss under advisement because they can actually rule on it at any time. That's one of the things about, working with judges that you have to get used to is they don't always accord with the timeline that we would like.
Well, no, but he's supposed to just go forward with discovery while the judge is sitting on his arse, taking it under advisement.
Oh yeah, you just move forward. It's in effect a denial, really.
Okay.
Right.
All right. Well, we'll see. We'll have to see what happens.
Yeah. I mean, I would love to see the motion to dismiss get granted. And honestly, the answer did a really good job of building out. I think John's lawyers knew, just as the church's lawyers knew, that these pleadings are not just being used to inform the court and to inform the other party. They're being used by folks like us and other people who are talking about this. There's an element of this lawsuit that is being tried in the court of public opinion and perception. And I think that's where the church is. You said, more money than common sense. I think they really are looking for any avenue they can to stem the tide of people leaving the church and criticizing the church. And they found a non-ridiculous legal theory that will allow them to strike back at one of their biggest critics. We literally know, and it's in the answer and counterclaim, that John Dehlin has been on their target list of the biggest problems facing the church for the last
Yes.
decade.
Yes.
So,
Good point. The bubble diagram.
mhm, mhm.
Good point. Yeah,
And
he's been on their sites for that long.
mhm,
And they already excommunicated the guy in 2016 or 15 or whatever it was, but it's just not enough. This
yeah,
guy won't
he
stay dead.
he can leave the church, but they can't leave him alone, I guess you could say.
He's like the
So,
guy with the hockey mask in those movies. They kill him, but he keeps coming back to life.
Jason.
That's who it is. That's John Dehlin. John Dehlin is Jason. The church keeps killing him, but then they look down where the body was and it's gone. And they go,
I think that's Halloween, actually. So, one of the things that the church did, in addition to filing its complaint in federal district court on April 17th, as you know, is they also simultaneously released a press release on its website claiming to, quote unquote, get it right. I've been a big fan of these church press releases since they did not one, but two on the Bisbee, Arizona case
Mm,
about child
they're
sexual
pleased.
abuse.
They're pleased, as I think was the second quote from the second release on the Bisbee case. How pleased they were that they won and that they got away with allowing those kids to be molested by their father.
Yeah, for 7 extra years. Here, this is basically me breaking down the first couple of paragraphs of the church's complaint. The church's main allegation, for people who aren't aware, is that Mormon Stories' use of the church's Mormon trademark and other related marks. I'm really going to focus on the Mormon trademark because the church, even though there are other trademarks involved in this, they wrap them all up together and basically call them the Mormon marks for purposes of the complaint. So they're alleging that the Mormon Stories' use of the Mormon trademark and other copyrighted materials, including a blue logo with light rays and design elements similar to the church's branding, has caused and will continue to cause public confusion about whether defendants' content is affiliated with or endorsed by the church. The church alleges that this similarity was intentional and designed to capitalize on that consumer confusion. Anything you want to add there about the theory of the church's case?
I just think that is a tough theory to prove. It's
Mhm.
like your theory is that there's, I don't know, there's men on the moon who are uniformly 10 feet tall and dressed as Quakers, or was it 6 feet tall? I can't remember. And they make green cheese at night when no one's looking. I mean, you can allege a lot of things, but how are you going to prove that?
Mhm.
Obviously, John Dehlin has a podcast. Obviously, there are these things, but how are you going to prove that part about this confusion? I know they tried to, and they were deceptive in their attempts to, and the answers showed that. The try to show confusion by comments of people that they
Right.
were alleging or portraying or presenting as if this is something that had happened in a vacuum, and these people had actually gone onto John Dehlin's website with no other knowledge. This was before November of 2025 when they even started this
Mhm.
action. Um, yeah. So how are you going to prove that? I just don't. It takes us back to where I was before with the swoop on the shoes. I just don't see how you prove that the church was damaged in some way. Are they going to say that he kept people from? You know what they should be arguing? They should be arguing that they've lost out on tithing of all the people who've left the church because of John Dehlin. That's what they should
I
be
th-
saying.
I mean, I think that's how they would have to prove damages,
Yeah.
but this is where the church probably doesn't want to make that argument because it's not a great look. But they've made arguments that aren't a great look all of the time that surprise the hell out of me.
Well, the
So,
surprise would be that this is actually what's going on. This is what's
mm,
really running this lawsuit. Is they're pissed
mhm.
at John Dehlin for the impact he's having on the church gaining and keeping members.
Even then, though, they would have to somehow trace the tithing loss directly to the confusion, not to John's commentary. They would have to tie it back to the confusion that John's basically capitalizing on their brand. Now, the best that they do in the complaint is they and this I pulled right from the complaint. All of these images are right from the complaint. They point to the fact that John's Mormon Stories logo from 2022, or that he began using in 2022, is similar in color and then in these geometric, they call them light rays design, but it's really just geometric triangles that change the shading of the shading of the color of blue
Yes.
To me, this is like a really common design element. Like the church makes a big deal in their complaint about how unique and distinctive this design element is, which is going to be something that they will have to prove is the
And
distinctiveness of the mark.
and the fact
And
that they have to go there indicates how desperate they are to put a case together. They
mhm,
just can't bring it only on the word Mormon, even though I'm convinced that's all they care about. They don't care about libraries. They don't care about colors. They care about the word Mormon. That's what they
mhm,
care about. But they can't just sail into the harbor with their one gunship of Mormon. They have to have all these other ships to make it look like you've got an armada.
right.
So that's what's going on, I think. And it's totally weak. They're pretending like it's not in order to try and give some oomph to the Mormon, which is the real thing that they're after. That's what I think.
Yeah, the other thing that they'll have to do, like in the complaint, they snipped all these social media comments saying, like, look at all this confusion. And John's lawyers did a great job of, and you did a great job on Monday of breaking down the timeline of when those comments actually came out, which is after the lawsuit was talked about, after the parties had already been dealing with this issue back in November of 2025 when it started. But in the church's complaint, one of the things I found so interesting is they redact off all the names and say, like, we've redacted off the names to protect people's confidentiality or privacy or something like that. I don't think that's going to ultimately be allowed. Like, if you're going to bring someone in to this lawsuit and say, here is a consumer that was legitimately confused
Mhm,
in discovery, John and his lawyers will have the right to basically depose that person and
mhm.
ask them questions because, again, this isn't just about confusion. It's about confusion to a reasonable and informed consumer. And so one of the instances or one of the ways that if it gets this far, John's lawyers will probably try the case is making the case that the people the church is pointing to who are confused are not reasonable consumers, that instead they're so in the tank for the church and church broke that they're just saying that they're confused and that their confusion
Mm,
isn't what the law is concerned about, that the law is
mm.
concerned about reasonable people's confusion. But, the church is doing the best they can with the arguments that they have to make,
Just
which
to
is like
underscore
you
one
talked
thing,
about. Yes,
I'm
of
sorry,
course.
yeah, underscoring one thing, this timing thing. The reason this exists is because of the way this happened. Now, if the church had just filed a lawsuit in April, which they did, and nobody knew it was coming, that would be one thing. But they started negotiations with John Dehlin in November, 5 months
Hmm.
earlier, I think, if I'm doing my math right. But 5 months earlier, they are negotiating with John Dehlin, and John mentions it, I'm sure. He mentions
Hmm.
it. In other words, it becomes public knowledge that the church is in negotiations and in mediation with John Dehlin. So after it becomes public knowledge that the church is moving against John in order to get him to modify his stuff because they're claiming trademark infringement and people are being confused, and the time that the church files the lawsuit 5 months later in April, it's during that time period that so many of these comments that the church used to try and show public confusion were posted.
Hmm. Hmm. Exactly, rather than before. And then there's just this question of, is that legitimate confusion or is that just kind of like team sports? In my view, it's just
Yeah.
team sports. It's just
No,
people trying to reflexively defend the church like they
it's
always
the
do.
height of the temple spire.
Exactly. It's exactly like that. But what the church has pointed to is that it started using this light rays design with the blue logo in May of 2016. This again comes from the answer and from the complaint. It's worth noting that since the church has made such a big deal of this light rays design, that John's lawyers did a great job of explaining Mormon Stories began using light rays in its logo design in April of 2011. Those two original the I think the complaint and the answer call
The
them the
gold?
gold or brown
Yes.
light rays designs, but those are the originals that I remember from Mormon Stories. And then
I'll
it's not
tell you that
until
John's team calls them the gold, designs, and the church calls them the brown designs.
okay. Yeah, so gold or brown, but those are kind of the original Mormon Stories logos for people that have been listening for a long time that
Yeah,
they'll
I
be
recognize them.
familiar with.
I
Mhm,
do.
totally. And then in 2022, John updated that logo to the light rays design that's at the bottom left of all of these images, that blue logo that, it's I mean, how how different of shades of blue can you really have, right? Like I see how a normal person who's not informed in what the law actually cares about can look at the fact that the logo is slightly similar to what the church has, but like how different can it really be when we're talking about, a logo that's this big?
Right. If
And
it's the color blue, how different can it be?
exactly. And I thought that John's lawyers in the answer and the counterclaim did a great job of explaining that they built this 2022 blue logo and this light raised design that the church alleges was intentional copying from the church's design, that they built this using a free online design tool that basically generated the design. And they point to that, which I found particularly hilarious because it really defeats the church's allegation that John's team did this intentionally if they were just using this free design that just slaps everything on this. It
Do
also
you think,
goes
do you think the
to,
church did their design for free, or do you think they paid millions?
I think that the implication is definitely there that somebody probably made millions off of using this free design tool to build the church's new logo. But yes, I did get a
And I
kick
bet we
out
would
of the way
recognize their
they,
last name if we heard it too.
yeah. Yes. And then as a result of the mediation, Mormon Stories moved to the orange logo that's at the bottom right that doesn't have any light rays, even though it's worth noting that John and his team had the light, if we're going to make a big fight about light rays, John and his team had the light rays 5 years before the church was ever using them.
You see, the what John has done is he's changed everything, uh, basically all the ancillary stuff, all the window dressing stuff. He changed all the window dressing, and he said, "On the word Mormon, I'm standing firm." And the church said, "Okay, we're going to file a lawsuit, and then we're going to pull a fast one. We're going to pretend that you haven't changed anything
Mhm.
when we file our lawsuit, and we're going to present it as if you're still doing all the things that you've already changed and complained about." And I think that was a big mistake on their part.
Right. And one of the reasons that is significant to me is when we were talking earlier about the issue of damages versus like injunctive relief or some other form of equitable relief. The church, for conduct that John has already ceased and stopped, like moving to this orange logo, the church would have to prove some form of economic damage or harm, as far as I understand, to be able to keep that allegation moving forward. Right. If I've wronged you, but I've made it right and I've stopped
Mhm.
it, and all you're going to be asking the court to do is to make me stop, there's nothing the court can do. That's what's known in legal terms as moot. Like it's something that's moot. The court can't do anything about it because the issue has already been handled by the parties or by some other, extraneous circumstance. But I'll be interested to see. Yes, you're right. The church's lawyers played very fast and loose with the timeline of when Mormon Stories was using these different logos and the fact that they had moved to the orange logo.
Yes.
So I think that kind of gives us a good overview of the first question we wanted to discuss, which is, did Mormon Stories branding create legally actionable confusion? That's what ultimately will be adjudicated by the court. This is really the meat and potatoes of this entire litigation. These other two questions kind of tie back to this question in different ways, but the big thing I want people to take away from this section is that not all forms of confusion are legally actionable. And the legally actionable form of confusion is from the perspective of a reasonable
Mhm.
consumer, not by some random member of the church that is saying on social media that they've been confused by Mormon Stories or deceived by Mormon Stories.
If this is the line of actionable confusion, okay, and John Dehlin's over here, let's just say that where they were before was approaching the line. I don't think it was over the line of actionable,
Mhm.
but it was approaching this line, maybe actionable confusion. I don't know. But when he made all the changes, what he ended up doing was retreating 3 steps
Mhm.
from that line. He's nowhere even near that line now, I think. And that's why I think this
Mhm.
motion to dismiss is going to win.
Yeah, it's very possible. So our second question, which does tie into the first, is how strong are the church's trademarks in Mormon and these other related terms? So this comes from paragraph 28 of the complaint, and this really shows what I said earlier, which is the church really is, you're right, making a big deal about the word Mormon or about these Mormon marks. They group up and have a huge table in the complaint of all, it's like pages and pages and pages of all of these trademarks that they have that are even implicated at all by the word Mormon. And so you can see there that the mark that they have, 3239919 for the word Mormon, is not for every single use case. It is specific to goods and services in the field of educational services, namely providing classes, conferences, and institutes in the fields of history and religion, as well as genealogy services. And the reason I'm including this is because I think there's been a lot of confusion on the apologetic side about how exactly this works. Like, trademarks are for specific fields. You can't just trademark a term in every single field. That would be ridiculous, right? That you couldn't have any type of similar name of another company, even in a completely unrelated field. Again, this comes back to the idea of legally actionable confusion. These laws exist to protect against certain forms of confusion, and some forms of confusion are entirely permissible.
Adidas heating services.
Exactly. Yeah, you can have similar named companies that aren't competitors or that aren't going to lead to actual consumer confusion. And I pulled these paragraphs from John's answer and counterclaim. These are specifically from the counterclaim section, paragraphs 3 through 5. If you wouldn't mind reading these for us, RFM, I think John's lawyers did a really, really great job of, in these paragraphs in particular, bringing to the public's attention what this lawsuit is really about.
Yes. Mormon, the word Mormon, is a vast and complex term that millions of people use and have used for over 200 years to identify themselves or others, their upbringings, genealogical roots, cultures, religious beliefs, and traditions, regardless of their affiliation with the corporate institution of the Church of Jesus Christ of Latter-day Saints.
I'll just pause you for a second and say, you and I have both been to Sunstone a number of different times. Like, Sunstone's literal tagline is more than one way to Mormon. Like, that's a really good summation of how this term is an umbrella term for more than just this single corporate institution.
Yes. And if Sunstone were put on by the church, it would be even more effective. By the way, should that be over 200 years or almost 200 years?
It should be almost 200 years.
I thought so. Okay, going on. Mormon, the word Mormon belongs to the public. It doesn't make any difference. I mean, it's almost 200 years. Mormon belongs to the public, including members of the over 400 different Mormon sects currently existing nationwide that trace their heritage back to the founder of Mormonism, Joseph Smith, and those with varied connections to Mormon history, genealogy, beliefs, and culture. Period. End of quote.
And I think aside from doing a really good job of bringing to the public's attention what this lawsuit is really about, we've seen a lot of national press pick up and talk about this part of the dispute. The other thing that this connects with me on is the fact that the church, I think it was in 2002, in 2002, Intellectual Reserve, which is the church's intellectual property arm, they sought a broader application for a trademark for Mormon for general religious services, namely operating places of assembly for worship and gathering, ministerial services, providing religious worship services, and conducting church-sponsored programs.
This is huge.
Yeah, this is a huge
So 2002, the church wants to get the trademark Mormon, not just for what they have it for, that religious stuff or educational stuff. And genealogical stuff. They wanted to use it for church stuff, basically.
Right.
Is that right?
A much broader term. Because if we go back, what they actually have protection for is for educational services, including institutes, conferences in the field of history and religion, and genealogy services. And the reason I'm drawing attention to this is because John has to be competing in those fields for this to be a violation of the church's trademark protections. And even though it's true to say that John talks about religion, I really think what John's producing is commentary on religion, not religious services or genealogy services or
institute
the history or institute
seminary classes. Yeah,
exactly.
Or genealogy. Yes.
And I think the fact that the church sought broader protections for the term Mormon, and those were denied back in 2003 by the U.S.
Thing. Denied. The church sought to get the word Mormon trademark for church related things, and it was denied.
Yes, and it was denied on the grounds of genericness, on the grounds that the term Mormon, much as John and his lawyers did a great job of explaining in their answer and counterclaim, like the paragraphs you just read, that is a term that had already become generic. You cannot protect a term that's become, or a brand name that's become generic. And so that's why the US Patent and Trademark Office denied that broader application. And it's worth noting that even though the church pushed it a little bit for several years, in 2007, they finally, the US Patent and Trademark Office, finally filed a notice of abandonment of that original application from 2002. So that is just a matter of settled law, that the church does not have as broad of protections in the word Mormon as I believe it's kind of trying to assert through this litigation.
Right. I think this is like trying to put the glass slipper on the stepsister's feet.
Mm-hmm.
It just doesn't fit.
Right. Now they'd have a much, it's just simply objective to say the church would have a much stronger case if they had received that trademark. If the US Patent and Trademark Office had agreed and said, yes, we're going to give you this broad use of the term Mormon in this entire field of offering religious services, of offering, what was it exactly? Of operating places of assembly for worship and gatherings. That's a much broader protection than what the church actually has. And I feel like they're still litigating this case like they didn't abandon that application, and that the US Patent and Trademark Office didn't deny it.
It's almost like they hope that the other side won't know. And that's usually not a good strategy for litigation.
No. I usually know when I was litigating cases, I often knew the other side's evidence and witness statements better than I knew my own, because that's how you win a case, is knowing the weaknesses in your case better than the other side does.
That's why one of my favorite quotes from Sherlock Holmes is when he's introducing himself. My name is Sherlock Holmes. It is my business to know what others don't know.
Oh, I love Sherlock. This comes from paragraph 16 of the complaint. And this one I found particularly interesting when we're talking about the issue of confusion and competition. Defendants admit that the church represented to the U.S. Patent and Trademark Office that its first use of Book of Mormon stories in connection with podcasts. I'll just pause for a second and say Book of Mormon stories is one of those similar kind of umbrella marks that the church is calling their Mormon marks. And obviously the reason, again, to your comment of trying to fit the ugly stepsister's foot into the glass slipper, the reason that they're doing this is because this is one of the trademarks that they have specific protection for podcasts in particular. So they're trying to make this fit. And so it's worth noting, though, that even their Book of Mormon Stories trademark, which does have connection with podcasts, they didn't start doing those podcasts until November 1st of 2010. It then continues several
5 years too late. 5 years after John starts.
Exactly. Several years after Dehlin began using Mormon Stories as the name for his podcast, and also represented under oath that no other use of a name similar to Book of Mormon Stories for podcasts at that time, which would include Mormon Stories, would create a likelihood of confusion with the church's podcast name. In other words, you can't trademark something that somebody's already doing. The entire reason that you trademark something is because you're staking your claim and saying, this is my business model, and now it deserves to be protected. This commercial interest deserves to be protected. But if someone else is already doing that, you're basically infringing on their intellectual property rights if you're the one who's second to the game. And so now that the church is pointing to this particular trademark and this particular avenue of competition, I see a real problem for them, because like you just said, John had already been doing that for over 5 years at the time that the church, filed an application for this mark, ultimately received this mark. But as part of doing that, they needed to say, we're not going to create confusion with other protected interests in this field, which now they've turned around and apparently forgotten in asserting that this mark protects them against Mormon Stories. It's a weird paradox.
In 2010, the church was basically arguing John's position.
Yes,
because if our Book of Mormon Stories doesn't cause any conflict with Mormon Stories, then I would think the inverse would be true as well.
Exactly. And that's where I can see legitimate grounds for like equitable estoppel or some other form of estoppel. Estoppel is basically an equitable remedy when a court says based on some factor, there's different forms of it. But a court basically says, I'm not going to even allow you to assert this interest based on whatever the factor may be. Equitable estoppel is basically that the equities don't allow you to assert the interest that you're asserting. And so I would not be surprised at all if, at least on that particular interest that the church has asserted, that they're equitably stopped from continuing to assert that particular interest based on that alone.
Good. They took this position. The church is the same party. You
Mhm.
have the identity of parties.
Mhm.
You have the fact that they were completely represented at the time, and the issue has to be decided, has to be relevant to the issue that's being litigated now, and I think it is.
Right. Right. And then our last question for discussion is these rebrand efforts, and did they weaken any claimed intellectual property rights? The reason that this is important, well, actually, I'll turn it over to you, RFM. Why is the rebrand effort important when we're talking about claimed intellectual property rights?
I think that this whole case turns on two things. The fact that John Dehlin has been going on Mormon stories and going strong since 2005 without the church raising so much as an objection to it until November of 2025. So that's 20 years. He is open and notoriously
Mhm.
doing his Mormon Stories podcast, and the church has not objected. That's the first fact that I think will,
Mhm.
and that alone, I think, would decide the case. But on top of that, you've got since 2018, the church as an institution disavowing and repudiating the use of the name Mormon. And those two things together, I think, are why it is, I think, the motion to dismiss will win.
Mhm. Yeah, and so legally, the reason that those rebrand efforts matter is because if you have abandoned an intellectual property right, which is generally demonstrated through some type of disavowal, which we'll talk about here in just a second, and
Mhm.
then an intent not to resume use of that particular mark, then that can be found to basically say you no longer have this intellectual property right. You have, for all intents and purposes, abandoned it.
Can I give you an example?
Of course.
And it's helpful to me only because not only because it's criminal, but because it's real world stuff.
Mhm.
So if you get stopped, if you're being chased by the cops, I'm sure you're innocent, but they've got reason to think you did something wrong. But you're being chased by the cops, and you got a backpack with you in your car, and in that backpack you got some stuff you shouldn't have, and that's probably why the cops are chasing you. Anyway, you can't get away. You wipe out. You pull off the road. You get out. You jump out. You're going to run now. You grab the backpack, right? And now you're running, and the cops are running after you, and you take that backpack and you sling it into a bunch of blackberry bushes,
Mhm.
and you keep going. And the police never catch you, at least not for several days. But they do go into the blackberry bushes, and they find this backpack that you threw in there. And they open it up and they look, and dang, if they don't have the drugs, and when they pick you up, you get charged with possession of these drugs. And there's a lot of them, and it's pretty good stuff too. So of course, your attorney brings a motion to suppress, saying that the police violated your Fourth Amendment rights to privacy by searching your backpack
Mhm.
without a warrant. And the judge says, motion denied, because the defendant abandoned his privacy interests in the backpack when he threw it away and kept running. So you
Mhm.
can abandon your rights to things. And that's just a very, very real world. And you can actually sort of see it happen in your mind. But this is analogous, I think, to what the church did with the term Mormon, is it threw it into a big sticker bush and it kept on running from the cop.
Yeah, no, I think that is a great application of the exact same principles, and you're right. Like, and that's one of the things I love sharing with people too about the legal field is my first job out of law school was working for a judge, as you know, and practitioners often, and especially lay people too, fall into this trap of thinking criminal law is criminal law, civil law is civil law, never shall the twain meet. The reality is doctrines between these completely different, disparate areas of law flow back and forth all of the time. Like, even though the concepts themselves are different, the application of them is often very similar. And that's a great example of what abandonment, my understanding of abandonment and intellectual property is. You need to demonstrate basically the some disavowal, some form of disavowal, and the intent not to resume use. And all of that can be inferred from circumstances. And so that's where then we, of course, turn to the church's rebrand efforts, because it's such a clear example of. Now, I'm a little bit more.
Can I just say, in my
Of
analogy,
course.
it's even worse than that, because the cops get it and they present it to the guy and they say, "This is your backpack." And he says, "Hell no, that's not my backpack. That's not.
That
I've never
backpack is a
seen that
major
backpack."
victory for Satan. That's what he says.
Exactly. I've never seen that backpack before in my life. It's not mine. So it's even worse for the church than in my analogy.
Mm-hmm. Mm-hmm. And this is where John and his lawyers from the actual counterclaim, paragraph 12, make this same case. I'll go ahead and read this. Instead, in 2018, the church publicly and expressly abandoned, to the extent it owned any rights in Mormon, which defendants do not concede, the very word Mormon that it now claims ownership and control of and sues to protect. Church president at the time, Russell M. Nelson, declared that the church would no longer use Mormon as an identifier, declared that Mormon was simply an adjective, and condemned its use as antithetical to the church's religious teachings and beliefs.
Thus, the name of the church is not negotiable. When the Savior clearly states what the name of his church should be, and even precedes his declaration with, "Thus shall my church be called," he's serious. And if we allow nicknames to be used or adopt or even sponsor those nicknames ourselves, he is offended.
Rusty doesn't like nicknames.
What's in a name? Or in this case, a nickname? When it comes to nicknames of the church, such as LDS Church, the Mormon Church, or the Church of the Latter-day Saints, the most glaring omission is the absence of the Savior's name.
The one we're not supposed to repeat.
To remove the Lord's name from the Lord's church is a major victory for Satan.
Yes.
When we discard the Savior's name, we are subtly disregarding all that Jesus Christ did for us, even his atonement.
But that is the abandonment that John and his lawyers point to, is basically this rebranding effort that started with that. It's worth noting, RFM, that even though you've been RFM since 2018, I was a fully believing member when he gave that talk, and I thought it was one of the most ridiculous things I had ever heard.
Yeah.
I really did. Like, I groaned at how ridiculous and trivial something like that would be. And like I said at the beginning of this, it's worth noting that, like, if you go to the version of that on LDS.org today, or whatever it is, churchofjesuschrist.org today, there's a footnote right in that passage that we just listened to in that talk that takes you to the actual revelation in the Joseph Smith papers, or maybe it takes you to the DNC section. But if you look up the original in the Joseph Smith papers, it's not the current name of the church. It is the wrong capitalization on the D and does not have the hyphen. And it's like,
so it's the Bickertonite spelling.
It's the Bickertonite spelling. That's exactly right. Yep.
Well, I guess they must be the true church then.
I guess he wasn't offended at the D or the hyphen. So
See, this is what it amounts to. I said that in jest, but then it occurs to me that there's too much truth in that remark. The Bickertonites are the true church then, since it really, apparently, the truth of the church is dependent upon the grammar and spelling it uses of its name.
Yeah, the Bickertonites are going to get impleted into this action pretty soon here. So here is from that same section of the counterclaim. If you wouldn't mind reading this, John and his lawyers do a great job of explaining it wasn't just this talk. There were extensive efforts that the church took in these rebranding efforts to get rid of the word Mormon from its official branding and trademark uses.
I'm just surprised they didn't include the Midnight Mormons changing their name to Psych Ward Radio, which is actually more fitting. Okay, here's what they wrote. Following this mandate from President Nelson, the church took dramatic measures for a period of years to omit all signs of Mormon from its official branding and trademark uses by, among other things, A, renaming the Mormon Tabernacle Choir. Nobody could believe it. This is gold. This is the example. You don't even have to get past A. renaming the Mormon Tabernacle Choir, a 150-year-old institution, America's freaking choir, to the Tabernacle Choir at Temple Square. Dumbest decision ever. B, renaming its Mormon channel to the Latter-day Saints channel, renaming its Mormon messages to inspirational messages, renaming over 1,000 products that bore the word Mormon, updating 300 web-based applications, and acquiring 800 domain names to purge Mormon from its vernacular and web presence. Nothing says you want nothing to do with the word Mormon like the actions the LDS Church took since 2018. Eliminating the entire website at mormon.org, eliminating it, and simply redirecting the domain to one of its web pages located at churchofjesuschrist.org, that's the one they use now, and issuing a style guide that is still in force today, explaining that Mormon is simply an adjective or proper name, not a brand, although I think the not a brand part was put in by the attorneys for John.
Mm-hmm.
Eliminating all use of the term Mormon as an identifier of the church, and instructing the media and public to stop calling the church Mormon and to stop referring to its members as Mormons.
And I don't know how many comment sections you've seen where members of the church get so pearl clutchy over use of the term Mormon. But they downloaded the new instructions from the prophet and they followed what he said.
You know,
And
I'm sorry.
go
An
ahead.
additional question that comes up is Mormon Stories itself. What function is Mormon serving in that title? I know it's artistic and it gets the highest level of First Amendment protections, but is it serving as an adjective or as a noun? Because it could be both. It occurs to me in that sentence.
Right. The stories of people who are Mormon or were Mormon. And it could also be
telling their stories.
Exactly. Mm-hmm.
So I think that, I mean, to the extent it can be reasonably understood, I think it can be reasonably understood both ways, but as a noun, calling the people Mormons, the church abjured that specifically in its style guide, didn't it?
Yeah, it did. It did. It took significant efforts to rebranding. And you had a great point on Monday's show where you said if you were John's lawyers, one of the first things you do in discovery is ask the church how much they spent on all these various efforts to rebrand. Because what that goes to show is how serious their effort was at this abandonment. And if you're going to infer abandonment from the circumstances here, you need to know the full circumstances and how much money was expended, how many of the widow's mites were spent actually making these changes, rather than someone having a conversation with President Nelson and explaining to the emperor that he has no clothes on. That decision.
I have to say that wasn't really my idea. I think that Rebecca came up with that. And then I thought about it and I thought, wow, that is a good idea.
Well, you can take credit for Rebecca's good ideas because she's not here.
I never do that. I try not to anyway. If she might be watching.
One of the next things I saw in John's answer and counterclaim that I thought was absolutely fascinating is these paragraphs at paragraph 14, which is what followed right after the one you just read. And then from later, they bring this back at paragraph 179. So they say, this explicit and sweeping abandonment did not extend to its averments made to the U.S. Patent and Trademark Office to speciously maintain federal registrations for the abandoned marks. Now, there's a little bit of that of begging the question, but that's very common in the way you have to plead something, is you're presuming that your arguments are correct. The real fact is found at this paragraph at 179, where they say, on information and belief, which basically means on what we're hoping to generate in discovery, on what we believe to be the case, but we can't actually show is the case yet. The declarants, meaning the declarants for an application to the U.S. Patent and Trademark Office that worked for the church, also submitted specimens that were altered to misrepresent the nature of the church's continued use of Mormon Tabernacle Choir. And again, it's worth noting, we already said this at the beginning, but that facts that are contained or facts that are alleged in a complaint or an answer or a counterclaim are not facts that have been established yet. There may be more to the story here. But if this particular part of John's answer and counterclaim are true, the church is going to have a real hard time, I think, with this abandonment issue. And what it shows for people who are just listening to us is in the answer and counterclaim, John's attorneys included a 2024 specimen that was actually submitted to the U.S. Patent and Trademark Office to show continuous use. When you're protecting a trademark like this, you have to show that you are continually using that mark in commerce. And
And we're
so as
talking
part
about
of that,
the Mormon Tabernacle Choir, because they have to go back
correct.
periodically and regularly and renew their trademarks. And when they go in, they have to show something, some bare evidence to the judge or the officer, whoever they're appearing in front of, the magistrate.
An
I've never done
examiner.
this before. The examiner. Thank you.
Mhm.
So you got to show them that you're still using the name. All right. So what do you do? Because this is the situation the church has put itself into. We have to go in order to keep this trademark, which somebody wants to continue to keep. I don't know that it's President Nelson, but the church's attorneys are going in there and requesting this to be renewed, the trademark on the Mormon Tabernacle Choir.
Mhm.
How are you going to do that when you've changed it? There's nothing within the last, I don't know, when was this done? 2024. So there's nothing in the last 6 years that you can lay your hands on that says Mormon Tabernacle Choir, because President Nelson did away with it all. But you have to come up with something. So what are you going to do? And this is the answer, or at least their answer to what are we going to do to come up with a specimen to show the Patent and Trademark Office that we are still using the Mormon Tabernacle Choir, right?
Mhm. Exactly. So what John and his attorneys show is that the 2024 specimen submitted to the U.S. Patent and Trademark Office shows this CD. I think it was a 2005 CD by the Mormon Tabernacle Choir. I only remember that it definitely predates 2024 because I had this exact CD when I was on my mission.
So it's a
And
2005 CD, and on the
right.
face of it, it says what?
It says Mormon Tabernacle Choir, Orchestra at Temple Square. The title of the album is Love is Spoken Here, but on their on their page for purchase at Deseret Book, it says Mormon Tabernacle Choir. What John and his attorney showed then is the same exact product page in 2026 that instead of saying Mormon Tabernacle Choir says the Tabernacle Choir at Temple Square, which makes sense because that is the formal name of the Mormon Tabernacle Choir after 2018's rebranding efforts. And so what they're suggesting here.
Yeah. Okay.
Oh, I'm sorry. Go ahead.
I was going to say, so in order for the church to be being honest here, all right, and still we're just talking about in a legal sense, to be honest, to not actually be perpetrating a fraud upon the court.
Mhm.
I think what we're saying is that the only way that can be true is if sometime between 2024, when the church attorneys went to the trademark office and presented the specimen of use of Mormon Tabernacle Choir in 2024, where if the church is being honest, it actually did say and was described in that red box as the Mormon Tabernacle Choir.
Right.
And it was sometime between 2024 and 2026 that Deseret Books or whoever in the church changed it to the Tabernacle Choir at Temple Square. But that seems really unlikely since the change was made in the name of the choir in 2018, correct?
Exactly. Yep. That's exactly what's at issue is John and his attorneys are basically pointing to this. And granted, it's on information and belief. So we would need to actually do discovery on how exactly this happened, but it doesn't look good for the church. What it looks like, and in fact, what John and his attorneys are alleging specifically is that the church should lose these marks, including the one to Mormon Tabernacle Choir, because they committed fraud on the U.S. Patent and Trademark Office by submitting that specimen that did not reflect the actual use in the marketplace. That's what they're alleging, is that you can't use this mark now to sue us or as part of your case in suing us because you committed fraud in maintaining this mark and not letting the U.S. Patent and Trademark Office know that you had done all these rebranding efforts and you haven't been using the word Mormon in the way you used to after that 2018 rebrand.
Because my understanding, though I haven't done it before, these renewal hearings, is it's in the form of an ex parte hearing.
Oh, yeah. I think most things with the U.S. Patent and Trademark Office are.
Well, in ex parte hearings, usually that means you're the only person showing up. The other side is
Right.
not there. They're not represented. And even though an attorney always has a very high degree of an obligation to be honest with the judge, candor to the tribunal, that is even heightened even more so when the other side isn't present. In other words, you don't get to say something when the other side isn't present that the other side would object to and show that it wasn't true. You don't get to take advantage of the fact that the other voice isn't there to slant things your way.
Right. But it's not like the LDS Church has a history of lying to federal government regulatory agencies, RFM, is it?
It's incredible. I just want to see this again because I want to really nail this down. Because if the church gets caught off first base on this, I think the judge is not going to be happy with him. So basically, what the allegation is, what the suspicion is, what the complaint is from the church, or not from the church, but from John, is that when the church went to the trademark office in 2024, they took this specimen because it says Mormon Tabernacle Choir on it because it's from 2005 and they haven't changed the cover. But in this square that's in red here, that it actually would have said the Tabernacle Choir at Temple Square, and that they artificially somehow changed the title as to its description in the red square. And that would be perpetrating a fraud upon, well, the trade office at least.
Exactly. And as a consequence of that, what John and his attorneys are asking this court to do is to say you can't use a trademark that you only still have protecting your interests because you committed a fraud in allowing it to continue on. And so asking the court actually affirmatively to recognize that the church no longer has a lot of these marks based on the fact that they had done these rebrand efforts and hadn't updated their actual commercial uses accordingly with the U.S. Patent and Trademark Office. So this is one of
I meant Patent and Trademark Office.
That's okay. This to me is one of the most interesting parts of the case, and I'm really interested to see where if the motion to dismiss is not granted and this does proceed to discovery, John, I mean, in some respects, the church will be lucky if the motion to dismiss is granted, because if the motion to dismiss is not granted, John has one of the coolest opportunities to do discovery on an institution on a lot of really interesting questions. Like, how exactly did this happen? How much money were spent on these rebranding efforts? Now, the church is going to fight tooth and nail, and nobody likes getting into the middle of a discovery dispute. They're very expensive. They're very time consuming. They, for both parties, run a huge risk of irritating the judge. But the church, again, the church is the one who brought this case, and they're going to have a lot less ability to say we shouldn't have to give over this information when they're the ones who brought this case and put these facts at issue.
Yeah, that's a good point. They've opened the door wide. By
so
the way,
any last thoughts on this? Oh, yeah, of course.
Yeah, I am hearing rumors, and I haven't confirmed this, about that at least one of the lawyers for the church who is alleged to have obtained this renewal of trademark by improper means is also representing the church in this action against John Dehlin. Had you heard that?
I have not heard that yet, no.
If there is an identity of the same lawyer, would that, do you think, make him need to withdraw from representation of the church in this matter, since he is also a fact witness?
I seriously doubt it. And I only say that because what the church's lawyers do in that respect is very similar to like what I do as an in-house counsel. And as long as there's someone else at the church, like I'm going to assume that there are non-attorneys that also helped with those applications, people who specialize in intellectual property that aren't the actual attorney.
Right.
As long as there's some other witness that they can use, most of the time judges are pretty lenient on that type of stuff if we're dealing with an in-house attorney. That's been my experience.
That makes sense. Thank you for that.
Yeah, of course. Any last thoughts on this third question, RFM? Did the rebrand effort weaken any claimed intellectual property rights? I think the simple answer is they absolutely weakened them. We just don't know yet whether they weakened them enough. And that's kind of the question that will be adjudicated.
That's true. And once again, my position is that it's irrelevant. It's gravy. And the fact that John was allowed to use this name of Mormon Stories for 20 years and the church didn't raise an objection, that alone wins it for him. This other thing just makes it, I think it's a lock. In fact, I'd be happy to bet you some good money on that motion to dismiss being granted by the judge.
I never bet against John Dehlin.
No, I meant against me.
But I'd be betting against John Dehlin.
Well, that's true. That's true. Okay, very good.
He'd be very hurt by that.
Yes, he would.
Here's just one little final note that there's so many interesting rabbit trails we could have gone down on this stuff, and I would have. Maybe we'll have to do that sometime. The two of us just go down every single rabbit trail on this stuff that we haven't explored. But one of the things I found really interesting is this whole note on disclaimers. So here are a few paragraphs from the complaint that I want to read. And I did not modify these. As you can see, I've got my citations there because the legal writing professor in me needed to show that you can read this yourself. It's right here. In adjoining paragraphs, I'm just going to read these and then I know you've already commented on these on Monday's show, but this to me is just absolutely wild. The church says in its initial complaint at paragraph 3, the church does not seek in any way to influence the content of defendant's podcast. And then it goes on to talk about what this case is really about, which I would say it isn't really about.
No, they got done talking with what the case is really about by out of the chute saying, this isn't what the case is about. This is how you always do it, isn't it? You take what it is the case is really about, but you don't want to say it. So that's the first thing you say is this isn't about what the case is really about. It's about this other stuff.
Mm-hmm. And this is where I would point to, you can tell that the church, just as John and his team recognize, there is an element of this case that is being tried in the court of public opinion. If you were just drafting this for the judge, you would have not had anything before the but, because everything before the but doesn't matter. You would have just had defendants should not be allowed to use the church's trademarks or other intellectual property. But they know that this is about the members' view of the church and the public's view of the church. And so they need to get across that the church does not seek in any way to influence the content of defendant's podcast.
Mm-hmm.
One of the things that's so confusing about this is literally the paragraph before that. They talk about the mediation efforts and they say, when the church approached defendants about their infringement of the church's intellectual property rights, they agreed to make some changes to what? To their podcast, but ultimately would not agree to take basic actions necessary to lessen confusion caused by defendants' infringements. For example, defendants refused to include a simple statement, either verbal or written, at the beginning of podcast episodes, acknowledging that Mormon Stories is not affiliated with the church. Again,
it sounds like the church was trying to influence the content of the podcast.
Yeah, those are directly contradictory. You can't say that John and his team didn't make changes to the podcast that you wanted, and then in the very next sentence, in fact, say that you're not seeking in any way to alter the content of John's podcast when you just said they didn't.
Except for the verbal disclaimers repeated every 15 minutes. We're not seeking to influence the content.
Yeah, absolutely wild. And then they said similar things in the FAQ at that press release where they said, to address that, the church proposed a simple solution, a brief disclaimer that the podcast is not affiliated with or endorsed by the Church of Jesus Christ of Latter-day Saints. Again, this is the church wanting to both eat its cake and then continue to have its cake. Mm-hmm. You can't say that you're not seeking to modify the content of someone else's podcast and then point to a fact where they didn't make a change to the content of the podcast that you wanted. This is the type of stuff that's just like, I don't understand, RFM, how members continue to tolerate this level of behavior from this church. I really, really don't.
It's astonishing, and it should not be overlooked. We pointed it out before, but not on this show, I think, that the church in its getting things right lied to its members and it lied to the public because it said that John Dehlin would refuse to put any disclaimers on his podcast saying it wasn't endorsed by the church when that was not true at all.
Exactly. And in fact, this is what John and his lawyers say. So paragraph 2, I'll read 228 and then maybe you can read the last two. They say in February 2026, defendants also adopted at the church's request a disclaimer consistent with standard practice in such situation. The disclaimer was placed in the footer of the Mormon Stories website and in the podcast description field on platforms carrying the Mormon Stories podcast. So wait a second. The Mormon Stories team made changes to the content of their podcast that the church says it wasn't seeking to alter in any way. It's just that contradiction is just so crazy that people aren't calling them out on that.
Yes. And I hear what you're saying. And so it's February, and they're putting disclaimers on. And then in April, the church is releasing something saying that John Dehlin refused to put on any disclaimers.
Exactly.
That's the Mormon Church. That's how it deals with facts. It does not tell the truth. And it doesn't tell the truth to its members about its own history any better than it tells the truth about what's going on in this lawsuit. Every page of defendant's website at mormonstories.org includes the following disclaimer. Quote, Mormon Stories is not affiliated with, endorsed, or sponsored by the Church of Jesus Christ of Latter-day Saints, period, end of quote. And yet the church told its members and the public that John Dehlin refused to put on any disclaimers. Shame on you, Mormon Church. And also, the church pressed defendants to have the disclaimer displayed and read audibly multiple times during every single podcast episode, and to place the disclaimer in bold white lettering in the top banner of defendants' channels and websites. And they said, no, we're not doing that. Okay.
Yeah, and I included this just...
The church could have said that in its release about getting things right, but it didn't. Instead, it lied and said that John Dehlin refused to put on any disclaimers.
Exactly. I included that last paragraph in particular to make that point, which is that the church often has this very weird way of not wanting to out and out lie. They will out and out lie, but you can tell that they're not comfortable with it. So they come up with these weird ways to justify to themselves that they're telling the truth. So because John, I guarantee the analysis goes like this: because John didn't include the disclaimers that we wanted, John refused to include a disclaimer. When in reality, John did include a disclaimer. He didn't include the exact disclaimer every 15 minutes of the podcast or whatever it said exactly that you wanted. I guess it just says multiple times during every single podcast.
Can you go back a couple slides? Because I think you have the actual language from that press release.
I do.
And where is from the FAQ?
It just says,
that's what it is.
To address that, the church proposed a simple solution, a brief disclaimer that the podcast is not affiliated with or endorsed by the Church of Jesus Christ of Latter-day Saints.
Right. And
this is a common and straightforward way to help audiences understand the source of content. That step was not adopted. That's just not true. That's simply not true.
Yes, and also above it where it says defendants refuse to include a simple statement, either verbal or written, at the beginning of podcast episodes acknowledging that Mormon Stories is not affiliated with the church. Isn't that part of their press release as well?
This is actually this is from the complaint. The bottom one is from the press release.
But the press release also says it even more clearly than that. That's not the entirety of the press. Do you have the press release?
I can pull it up. Yeah.
Yeah, and I'm sorry, and I will too, actually. What is it called? Getting things right, getting it wrong, getting it right. LDS
getting it right.
Release.
I've got it right.
Okay. Because they actually went too far. I mean, they walked up to the line like you're talking about, but then they walked over it when they said this. Okay, what happened? Why does it matter? Why was mediation unsuccessful? Yes, here it is. That step was not adopted. Did you read that already?
I did. Yes, this is what I read.
That's
the primary issue. Let me read it really clearly, though, so everyone has it. The primary issue is ongoing confusion about whether Mormon Stories is affiliated with the church. To address that, the church proposed a simple solution. So already, let's just pause there. That's a lie. It's not a simple solution to include multiple disclaimers throughout the course of an audio podcast. That's not a common thing that's done.
Right. So and the way they're characterizing it to the church and to the public is all they wanted was a brief disclaimer.
Exactly. A simple solution. They even call it a simple solution. Oh, I'm sorry. I hadn't displayed that. Here it is so that people can see it.
At the time that they're writing this, there have been disclaimers put on every episode for at least 2 months.
A brief disclaimer that the podcast is not affiliated with or endorsed by the Church of Jesus Christ of Latter-day Saints. Again, it's just this is just where the church just gets too cute by half. Like, to anyone who isn't just completely in the tank for the church is going to believe anything they say at face value.
Yeah, this is a common and straightforward way to help audiences understand the source of content, period. That step was not adopted, period. End of quote. That means John Dehlin refused. What did John Dehlin refuse? He refused to adopt the church's proposed simple solution of putting a brief disclaimer on his podcast that it's not affiliated with the church, when he'd already been doing that and they knew it.
Yeah,
And of
he
course,
did place it. He did place it on his website, and he placed it in the footer of the podcast, and I think it's in the description of his YouTube channel. If I'm steel manning what the church is saying, even though I acknowledge there are multiple lies in that statement, he does not have a disclaimer at the beginning of each episode. So that is the only avenue I can see where they could say, here's why we didn't lie. But
it doesn't say a brief disclaimer at the beginning of each podcast.
correct.
It just says a brief disclaimer, and he'd already done that. It's a lie.
I think it
You can
does.
Yeah, you can steel man that lie all day long. It's still going to be a lie.
Well, at least in the FAQ, in the press release, they lie. At least, and notice the difference. In the complaint, they say defendants refuse to include a simple statement, either verbal or written, at the beginning of podcast episodes, acknowledging that Mormon Stories is not
Now,
affiliated
that's
with
in the
church.
complaint, just so everybody understands. That's in the complaint they filed with the court. What I'm reading from over here is the press release they released to the public about it.
Right. So they're more willing, when someone's law license isn't on the line, I guess it's worth noting, they're more willing to play fast and loose and play cute with how they word these things. Because I don't see any way to steel man the press release version of what they said to it not being a lie. I really don't. I would love to hear someone who wants to make that case. If you want to make that case, please email me at letsdisagreeshow@gmail.com, and I will roll out the red carpet for you. And I may be accompanied by a friend.
And you could actually have someone on who disagrees with you for a change.
I've
On the
had
Let's
people on
Disagree
who
show.
disagree
You will have
with me.
people. You will have disagreements on your Let's Disagree show, won't you?
I've had disagreements.
Okay, I got to ask you this though. Got to ask you this.
Yes.
The fact is, as best I can see it, is that the church has lied to its members in its press release. The fact is, as best as I can see it, that many of the church's minions, such as Jasmine Rappley and it's the usual
The
suspects,
usual suspects. Yeah.
they ran with that and reported that breathlessly to the public that John Dehlin is a no good so-and-so because he refused to even have a brief disclaimer that his podcast is not affiliated with the church, because obviously then he wants people to be confused and think that his podcast is affiliated with the church. And when you find out, you must at some point, that the church was less than straightforward with you and actually didn't tell you the truth, that you went and repeated to your audience, the church made a liar out of you. How do you respond to that as a podcaster?
Well, I struggle with that question because I would have fact-checked what the church said before I did any episode about it. But I think this just kind of reveals the difference between the methodological difference between how most critics, at least the ones that I engage with, deal with issues and the way that these apologists deal with issues. These apologists, the ones that you've mentioned, Jasmine Rappley, Jacob Hansen, Ward Radio, all the folks that had took their victory lap when the church filed this complaint, they were so eager to celebrate their victory, their big victory of the church filing a complaint, that they didn't do basic fact checking. They didn't go look. One of the folks that I saw that did the victory lap was Dan Peterson. Well-known
use a few
apologist.
victory laps. Well, you've got to get in the shape so you can jog the Krispy Kreme on Saturday morning. You know that.
Oh, that was good. Yes, he could use a few victories.
He plays it with Walkman on. It's got a cassette tape on it with Queen's Greatest Hits playing. I Want to Ride My Bicycle.
Oh.
I don't know where this stuff comes from, folks. Honestly, I don't.
What does DNC 88 say? The Spirit shall bring the words to your remembrance in whatsoever very hour you need of them. Something to that effect.
It really does that to me, and it does it with the scriptures as well as other things. I think that's true, at least for me, and it's never been more true since I disaffiliated myself from the church.
Yeah. Dan Peterson was one that took
It's a strange
victory
thing.
lap
You want
on
to be
his...
philosophical for a second? I know we've gone into too long. How long are we going?
We're almost
done. Right. That's what we
You're
were.
good.
Dan Peterson took a victory lap on where? Where is he now?
on his blog, and then he posted it on Facebook, and for some reason it got pushed to me. So I commented about that line in particular and said, and I went and did a screenshot of the disclaimer on the website. And I was like, the disclaimer is right here today. What does it say about you folks that you won't even go look and check and see if it's there before you take your victory lap?
They believe that the church is telling them the truth. And you would think that after a time or two of getting your fingers burned because of that, you'd learn your lesson.
You would think, but it's almost like maybe it's not about truth for that crowd. I don't know, RFM.
The truth is what makes the church look good.
Mhm. One of the things that is included in the answer and counterclaim as an exhibit that helps kind of finish out this point is there's an email from John to the folks that he was working with at Intellectual Reserve to basically point to the fact that they had included this requested disclaimer language in the description of the podcast on all platforms. And granted, we don't know the other side of the story. We only have this one email, but here's how it reads. As a courtesy to you, we would like to list the changes that we have made, either in response to your original emails or as a result of mediation. We have changed the background color of the Mormon Stories logo. We have removed images from our social media banners that were deemed too similar to the church's light rays and or Christus trademark logos, or that were images revealed to be copyrighted by the church. We recreated and replaced several years worth of YouTube thumbnail images that were identified as containing images possibly copyrighted by the church. We again invited you to enumerate any other specific usages of concern. We included your requested disclaimer language in the description of the podcast on all platforms. We made my name, Dr. John Dehlin, more prominent in the podcast description to help ensure people do not consider Mormon Stories to be an official LDS Church sponsored, produced, or affiliated podcast. And I guess I just would say, again, I only have access to what was attached, but it would seem like if they weren't happy with the disclaimer that John provided, the time to tell John that would have been, I don't know, in response to that email.
Before you file a lawsuit?
Before you file a lawsuit and lie about whether he has included any disclaimer at all.
Can you go back to that letter? Because I think that's all very important. I just have a question, and it's like, what is this bullshit with Brother Taggart? Dear Brother Taggart? What the hell's that about?
I don't know. I would have called him Mr.
That's weird.
Yeah, John says he still considers himself Mormon, so maybe that's part of it. I don't know.
I guess the lawyer who's trying to ream him a new one is still his brother then.
Well, he's trying to be conciliatory, so I don't blame him there. Okay, let's talk about what's next, because there's one thing that you have mentioned a few times, but I have not talked about, which is the motion to dismiss has two theories in it. The first is fair use, which we basically have talked about, I think, all throughout, is basically that the use of these trademarks at all by John, if he even has used the church's trademarks in any way, that use amounts to fair use, and thus it's not actionable. So that would be grounds for a motion to dismiss. The second one, which you've talked about a lot, is this idea of the church sleeping on its rights. This is a common law doctrine known as the doctrine of latches. The doctrine of latches actually predates statutes of limitation, and it's kind of the similar idea. It's an idea that you waited too long to assert your rights, so now the courts are not going to help you. In this particular case, I think you've done a good job of summing this up, which is John has been using the same name, the same basic branding, including the light rays on the gold or brown logo, for over 15 years at this point. I think he started first using that in 2011. He first started podcasting in 2005. One of the things that I think John and his attorneys did a really good job of building out throughout their answer, even though they don't have a ton of legal significance, is how known to the church John Dehlin is, how known to Dallin Oaks John Dehlin is. They lay out his personal letters and exchanges with Dallin Oaks. And the point that they're making is he's not some rando. He was well known to the church. They even have an image of that of that bubble image that folks are familiar with, that Mormon Leaks leaked, where it's basically a list of the people who are the biggest threats to the church. John Dehlin is featured on that prominently as one
And this
of
is
the.
before he was excommunicated.
It
It was
is.
before, it's over 10 years old.
It
They've known
is.
about this guy for a long time.
It is. They've been trying to hide him for a long time. But the whole idea of the theory of latches is that you have slept on your rights, and thus the courts are not going to enforce those rights for you now. And I think the church is going to have a really hard time asserting an interest in the word Mormon when you combine the idea of latches with the idea of the rebrand efforts and how that affects the strength of their intellectual property rights. I know you've said throughout our conversation that you feel like that motion to dismiss will probably be granted. And are you guessing on the theory of latches mostly?
Yes. Yeah, those two things combined, I think. And here's the thing I've learned after 36 years or whatever it is in law, is that when you get a case initially and you go over it, now you're going to, before trial, this is a case that's going to go to trial. You're going to live with this case. You're going to know it inside out. And the problem is psychologically, at least for me, is that when I see a case for the first time, there are certain ideas that hit me and they're obvious. And this is what the case is about. Those are correct because those are the same ideas that the jury is going to have. The jury is not going to live with this case the way you are. You're going to go on and you're going to continue to live with this case for months and even years. And what you can do, the peril is forgetting what it was that impressed you first as you get further and further away in the weeds and you start finding all these interesting little things in the weeds. Well, these little things in the weeds that are now taking your attention away and you're thinking are so wonderful are little tiny things compared to these big hammer blows that hit you at first. And the things in the weeds are not going to impress the jury. But by the time you get to the jury, you may think that those little things in the weeds are what you want to lead with the jury, and they're not. It was the things that impressed you in the first place. So using that thing that I've learned, I think that the things that hit you in the first place right in the face about this, even though there's many interesting things in the weeds, are that 20 years John Dehlin's used Mormon stories without any objection from the church and the church's mission to disavow and not use Mormon since 2018.
The other thing I'm really struck by on the theory of latches and this idea of delay is, again, if the motion to dismiss is not granted, if I get my wish, but it's not because I don't want the motion to dismiss not to be granted, it's because I want discovery to happen. And if discovery happens, John and his attorneys have a really amazing opportunity to dig into the church's internal communications and stuff specifically as it concerns John Dehlin and Mormon Stories, because they will get to build out more of this case of the church knew about this for so long. They have had him on this list, on this bubble, slideshow of people that are affecting and drawing people away from the church. I think that will be really, really interesting opportunity for John and the Mormon Stories team to dig into why the church slept on its rights, potentially.
Even a very interesting, very side issue, which is like, okay, so who made this freaking slide with all the bubbles on it? Who did that? And why did they do that? Why was the purpose of putting John Dehlin in there? And why was he such a menace and a problem that you decided to include him? Just one named individual. There are several others. There's like
Denver Snuffer was on there. Kate Kelly was on there.
Yes. But other things are organizations, I think, that are problems for the church and even just concepts. So, yeah, that would be interesting to know. But I think that John Dehlin would sleep better at night if he got his motion to dismiss granted, don't you think?
Absolutely. Yeah, he's getting too thin anyways. We don't want him to suffer that much stress.
My goodness, if he gets any skinnier, he'll have to run around in the shower to get wet.
Well, RFM, I've had such a great time breaking this down with you. I think whatever ultimately ends up happening with this case, obviously it's affecting a personal friend of both of ours. So being sensitive to that, but also being someone who loves really interesting lawsuits and how they can resolve some of these really interesting questions, the three that we've looked at today, and then a bunch of other related questions. I think the thing that's really interesting to me about this case is it touches on a lot of different elements. It touches on First Amendment law. It touches on intellectual property. It touches on, like you talked about, how a church can assert interests that we normally associate with like a for-profit commercial venture. I think it just is such an interesting case, and really is going to give us some interesting insight into the way the church functions. I think, regardless of how ultimately this case resolves, this church, or I'm sorry, this case, even if the church were to win, will be nothing but a Pyrrhic victory. If Mormon Stories ultimately ends up having to change its name, there are millions of people who have heard about Mormon Stories as a result of this lawsuit that the church brought that probably never would have heard about Mormon Stories. Which, just from that lens, if the church's big concern was John Dehlin and Mormon Stories leading people out of the church because of this confusion, well, I think they just are maybe tilting at a windmill that they really haven't considered what their victory down the road could even possibly be. Because even if they win money from John Dehlin, even if they get an injunction telling him to change his name, even if they get everything they're asking for and more, I really don't think they will win any victory that's significant.
No, because at the end of the day, the optics are you've got a big, gigantic church, a $300 billion church that is trying to at least put a little podcast. It's a little podcast compared to the church. It's a tiny guy who's just given his opinion about the church and saying, you can't do that. And we are going to use our entire law firm and all our money behind us to put you out of business and to make it so you can't criticize us anymore. Because that's really what I think it's about. And I think that if the judge sees that same thing, then everything will go for John.
I agree. Well, RFM, thank you so much for joining me. And folks, thanks for joining RFM and I, two randos on the internet talking about this Mormon Stories lawsuit. RFM, do you want to tell people about your platform and podcast while I've got you here?
You're so kind. It's Radio Free Mormon. I hope you'll watch it. It's been around for 10 years. It's still going strong. I like to think it's getting better and better. I keep learning more and more about this church and being opened more and more to the workings of the human mind, which are an amazing thing, especially when it interfaces with religious beliefs. I am more and more coming to understand that what Dale Carnegie said in a book that I read when I was on my mission. I wasn't supposed to be reading it, but I got it at a bookstore. And I read it. He says, he's quoting somebody saying, most of us, we pick up our beliefs on the street corner and then we fight to the death to defend them. That's crazy, isn't it? But it's true, right? We'll just take these beliefs anywhere, but then, man, we will fight to the death to defend it.
Absolutely. And if folks have really enjoyed this conversation and enjoyed the chemistry that you and I have together, I would be remiss if I did not point them to our literal year-long effort of responding to a really terrible apologetic work known as the Light and Truth Letter, written by Austin Fife. And folks who have emailed me, and probably RFM, you've gotten some of these too, that Austin Fife has written a new book and asked if we will be going through this. There is not enough money in the world to make me read another Austin Fife book, as much as I appreciate the love and appreciation that people showed for that series. So if you want to check out a long form, and when I say long form, I mean, what did we ultimately calculate it to? Like 60 hours of content?
It was a lot longer than the Book of Mormon.
It was longer than the Book of Mormon, and much longer than the Light and Truth Letter, and much more cogent and knowing, I would say. So if folks want to check out
Austin Fife, I know you're trying to wrap up the show, but I'm not going to let it happen. I'll keep throwing my body across the train tracks. So the thing is that his book it stinks. Okay, you say it was written by Austin Fife. I would just say it's written by Austin Fife's computer. But the thing about it is that it still goes over the different issues in a horrible way. But we come in and we steel man all the issues. So basically, by watching our show, you get the response to all of these different things that apologists say. And we don't, there's sometimes where we kind of make fun of how bad his arguments are. But we do.
Sometimes.
It happens. But there's a number of steps, especially when in the first chapter, by the way, if you haven't seen any of this, he lists all these different logical fallacies that he alleges that critics use of the Book of Mormon and Mormonism. And then he proceeds to use every single one of them multiple times throughout his book. And we document all that.
And my favorite part of that is that his wife argued with me in a comment section about how just the fact that he indicated those in the first chapter doesn't mean he can't use those sometimes, which was honestly adorable. Chef's kiss, no notes. Fallacious arguments are fallacious arguments. It doesn't matter which side you're using them to defend.
That's like almost a double standard
Weird.
of evidence, isn't it? He can use
That's
them, but
odd.
you can't. That doesn't seem right. That seems like a logical fallacy.
Yeah,
So,
I don't want to play heads I win, tails you lose.
So Austin Fife's wife, the Fife wife, used a logical fallacy to defend Austin Fife's use of logical fallacies.
Mm-hmm.
Got it.
Yes. Fallacy on fallacy. It's fallacies all the way down.
So
that is a good tagline.
It's so great just on the logical fallacies thing. I mean, we got so much in there. Just logical fallacies. You will learn your logical fallacies and how to use them from Austin Fife and how to identify them from us. And so that's great. And then also you get just basically everything there is on Mormon apologetics. You can go through it and you can find out what the answers are to these attempts by Mormons. And I used to use them to try and prove the Book of Mormon true by different kinds of evidence.
Yeah. And we'll be doing another episode on Wednesday, right? You and I, Mormonism
That is the
Live?
plan, a Mormonism Live, to come on, and we're going to talk about this. It's Jasmine, isn't Jasmine without an E?
Yes. Jasmine Rappleye.
Yes. Rappleye. She gets very upset when you call it Rappleye.
Oh, okay.
Yeah.
Okay. Well, I'm looking forward to that, RFM. You are one of my favorite compatriots to do counter apologetics with, because honestly, folks, I do that Light and Truth Letter series is such a good series. If you want to understand the issues confronting the Book of Mormon, good critical responses to some of the very common apologetic talking points. The bottom line is, anytime you look even slightly a little bit closer, those arguments fall apart and evaporate. So RFM, thank you again for joining me. Folks, thanks for joining us on another episode of Let's Disagree. Please like and subscribe. Check out RFM's channel. And thanks again.
Thank you, Kolby. Good night, everybody.
Thank you.
Well, that concludes our discussion. Okay. Well, that concludes the discussion that Kolby Reddish and I had about the subject of John Dehlin's filings in response to the church's lawsuit. We'll see how this plays out. In the meantime, please don't forget to hit subscribe here. Please don't forget to hit like here. If you've made a donation, thank you so much. If you haven't, what are you waiting for? Please go to radiofreemormon.org right now. Make that donation today. $5 a month, whatever you can afford. Your donations do keep Radio Free Mormon broadcasting behind enemy lines. Well, that's about all for tonight. Until next time, this is Radio Free Mormon, signing off the air.